Straight ahead on Law and Crime Daily, honoring the life of Supreme Court Justice Ruth Bader Ginsburg.
A system of justice will be the richer for diversity of background and experience.
And former That 70s Show star Danny Masterson appears in court on rape charges. His defense lashes back.
Also, 8 people killed in rural Ohio. The case against one of the defendants accused of playing a role in a massacre.
Plus, the state tries to stop a judge from dismissing the case against one of the cops accused of murdering George Floyd. Law and Crime Daily covers court cases from coast to coast. And welcome everybody to Law and Crime Daily. I'm Aaron Keller along with Brian Buckmeyer and Terry Austin. We begin with reaction to the death of Supreme Court Justice Ruth Bader Ginsburg. A black cloth draping the seat on the nation's high court, which Ginsburg occupied for 27 years. The practice of mourning a justice in such a fashion dates back to at least 1873. The late Justice was a champion of women's rights and an advocate for gender equality. She attended Columbia Law School, was a professor at Rutgers Law, and served as an attorney for the American Civil Liberties Union. President Bill Clinton appointed her to serve on the Supreme Court in 1993, after she sat on the D.C. District Court of Appeals for 13 years prior to that. She was the second woman to serve as a Supreme Court justice, and her words at her nomination reflected her hope that her achievements would pave the way for others.
In my lifetime, I expect there will be, among federal judicial nominees, based on the excellence of their qualifications, as many sisters as brothers-in-law. That prospect is indeed cause for hope, and its realization will be cause for celebration.
Terry Austin, your thoughts on Justice Ginsburg. How are you remembering her?
Well, you know, I have a very special place in my heart for her. She is actually the picture on my Facebook and has been for years. And the reason is she did so much for women in terms of equality. Her point was, don't put us on a pedestal because that's not treating us equally. It's unfair to do that. And she started her career very early, making sure she picked and selected cases that really made a difference as far as that's concerned. And I was very fortunate enough to have the opportunity to sit in on her class when I was at Columbia. And I got another professor for constitutional law, but all of us would try to, squeeze into her classroom because even back in the 80s, she was someone who was much of a legend back then.
Just someone you wanted to see sit in on the masterclass. Brian, reaction from the conservative wing of the court here. Clarence Thomas saying that she was the essence of grace, civility, and dignity, called her unfailingly gracious, and said he will dearly miss his friend. Samuel Alito saying she'll go down as a leading figure in the history of the court. Brett Kavanaugh even saying that he keeps and will continue to keep a picture of her in his office. So people respected her a great deal, even if they disagreed with her legally.
She was greatly respected because while many people were playing checkers, she was playing legal chess. I mean, I would encourage people to go back and not just look at her as a justice of the Supreme Court, but also look at the work she did in the ACLU. Look at Frontiero v. Richardson, Weinerberger v. Weinsfield, U.S. v. Virginia, Oberfield v. Hodges. She laid the groundwork for so many people, and talking as a person who their rights can be connected to so many other U.S. Supreme Court cases. My ability to love my wife, my ability to be more than 3/5 a person. I tip my hat to this woman because she did so much for so many.
We remember her through her jurisprudence, and if you haven't read it, it is certainly worth reading. An actor best known for his role in That 70s Show appeared in court for the first time to face rape charges in a case associated with the Me Too movement. Danny Masterson is accused of raping 3 women in his home between 2001 and 2003. The women came forward 3 years ago, but Masterson was just arrested 3 months ago. Masterson is out on more than $3 million bond. His attorney insists he's innocent. Here, the judge explains Masterson's rights, an important part of any first appearance.
Your attorneys may appear in court on your behalf without you present. Yes, Your Honor.
Do you also understand that you must be present anytime the court orders you to be present for any substantive hearing, for any preliminary hearing, for any trial, and for any disposition in this matter?
Yes, Your Honor.
Mr. Masterson, your attorneys have filed a demurrer in this case. I have just set a briefing schedule. That demurrer will be litigated very likely at the next court date. Do you understand that you have the absolute right to be present at that hearing and give up that right and agree that your attorneys can appear on your behalf?
Yes, Your Honor.
Masterson's attorneys asked the judge for a protective order to prevent information about the case from being released to the public. Prosecutors agreed with the concept, but said the motion was just too broad.
This protective order, as it's currently drafted, as it's constructed, is objectionable. First of all, it's overbroad. It's grossly overbroad. And I think it asks this court to exercise jurisdiction over parties, third parties, that is beyond the scope. It needs to be more narrowly tailored. I think as it's written, it's grossly overbroad. And again, I think also premature, since counsel has not yet reviewed the evidence. They don't know what it's contained and what their order is asking to limit in terms of the disclosure.
That defense motion denied. The victims filed civil suits against the actor and against the Church of Scientology last year. Local reporter Carrie Antholis explains what's behind those related civil cases.
4 victims have come forward, and I believe 3 of them are included in the criminal indictment, but 4 victims have alleged that the Church of Scientology and Mr. Masterson covered up and tried to intimidate, bully, assault these victims in a civil case that was filed last year. And included in those allegations are that a dog was poisoned, one of the victims' dogs was poisoned, and so the intimidation tactics are part of this, or the alleged intimidation tactics are part of a civil suit that's going on in Los Angeles Civil Court right now.
Let's jump in with some analysis right now. Brian Buckmeyer, let's talk about this case because procedurally the posture is interesting here. We've got accusations going back 17, 19 years. Is there a benefit to prosecuting a case that old, or is there a drawback?
There's definitely a drawback. I mean, some people can't remember what they had for breakfast yesterday, but as time goes on, your memory decreases, and it becomes that much easier for a defense attorney to poke holes in that. However, we've seen the way be paved in the Harvey Weinstein trial and the Bill Cosby trial, and that might not be as difficult as it was in years past.
So Terry, when we look at the law here, usually a statute of limitations is in place, I should say, as well, to prevent a prosecution against accusations this old. But as we've seen with many sex-related crimes, oftentimes legislatures are opening up that statute of limitations.
Well, that's exactly right. You know, in California right now, under the Penal Code, it's a 10-year statute of limitations with some exceptions. So, for instance, if the victim was under 18 years of old. But we're seeing that that's looking to be expanded just because of the cases that Brian just mentioned, the Bill Cosby case, et cetera. And I think legislatures and individuals in general are looking to extend the time so people can bring these charges because it's difficult to bring them initially.
And we're seeing an example of that right now, Terry. So what's your thought on this? Better or worse for a prosecutor to try to go after a case like this?
Well, I think it's going to be more difficult for the prosecutor. The more time you have, obviously, the less evidence you're going to have.
Certainly. Terry Austin. And still ahead on Law and Crime Daily, officials in Louisville, Kentucky are bracing for what could be an imminent decision involving the police officers who killed Breonna Taylor. And one of the many defendants accused in a killing spree involving a custody dispute is back in court. That and other reports when Law and Crime Daily continues. Welcome back, everybody. 2 federal buildings in Louisville, Kentucky are closed this week over a big decision from local authorities. Sources tell local TV stations there that a decision on whether to criminally charge 3 police officers over the killing of Breonna Taylor is expected to come this week. The federal courthouse is closed and boarded up in case protests break out. All scheduled hearings there have been pushed back or will be done by video conference. The decision on whether to file charges rests in the hands of the Kentucky Attorney General. The AG's office has refused to provide a timeline on when an announcement might occur. Taylor was shot and killed, of course, during a no-knock raid on her apartment, conducted by plainclothes officers. The case against one of the key defendants in Ohio's so-called Pike County massacre is slowly moving along. Jacob Wagner, his brother George, and their parents are charged with murdering 8 people in 2016, but charges were dropped against grandmother Frederica Wagner. Authorities say members of the Roden family were killed over a custody dispute involving a young child Jacob Wagner shared with Hannah Roden. Wagner's attorneys filed several motions in the case. A full hearing has been delayed until next month.
The defense was taking the position that it would seem to us, for example, that just as an example, statements attributed to Angela Wagner regarding a certain set of shoes seem to be fundamentally admissible if and only if the court ruled in the state's favor as statements of co-conspirators. And Counsel Wilson mentioned that may not be the only way. That statements and perhaps others like it may have a pathway to admissibility for the prosecution. Long-winded way of saying is there may be more fighting and writing to be done as we progress on these particulars.
It appears the trial could come down to a battle of the experts. One of the big questions is how forensic analysts are interpreting bloody shoe prints found at the crime scene.
The majority of stuff has been provided to them. We provided them all the bench notes for all of our expert reports from the Bureau of Criminal Investigations. However, in the most recent discovery dump, we gave them 2 new reports that we did not give them bench notes for, but they're now requesting those. And then we did not have bench notes for Dr. Bodziak, so we will attempt to get those.
Okay, let's jump in now. This was supposed to be a big 2-day-long hearing, Terry, and now we've got word that they're trying to shut things down because one of the attorneys might want to retire and things like that. So when you've got this many defendants and this drawn out of a proceeding, doesn't the judge want to get in here and say, let's move this thing along?
I would think so, Aaron, because this case took place, I remember when it happened now in 2016. That's a long time ago. It's 4 years now. And when you have a case of this magnitude where an entire family, 8 members, were killed, that's something you don't want to delay. So I would think that the judge would tell the attorneys, look, you better get moving here. We've got to get started. Even with COVID-19, we still have to make sure that justice is served here because this was brutal.
And Brian, what's going on with the arrest of the grandmother? Then that case ultimately gets dropped here. So do prosecutors have their act together on this one or not?
9 times out of 10, the answer is usually no. But this is a complicated case. There's a lot of moving pieces. I mean, even as I'm reading it, you've got so many defendants, so many victims, the ballistics. I mean, the defense attorneys, I'm assuming, are going to be jumping up and down, screaming, fry hearing, which is the standard by which you can scientifically assess things like the ballistics report or the shoe print evidence. So there's a lot of moving pieces here. I wouldn't lay it at the feet of any one group of people, judge, defense attorney, or prosecutor. I think it's just a difficult case to prosecute.
And of course, Terry, a collision between the rights of the various defendants as well, oftentimes, in a situation like this.
Well, that's right. I mean, they're sitting waiting for trial, so their rights are not being abided by right now at that point, too.
Exactly. Got to make sure everybody gets a fair trial. And later on the broadcast here, the strange legal argument being made by attorneys representing a mother accused of playing a role in the deaths of her children. But first, Minnesota prosecutors are trying to stop a judge from throwing the murder case against ex-cop Derek Chauvin out of court. We break down their arguments next on Law and Crime Daily. Minnesota prosecutors are fighting back and against an attempt by Derek Chauvin to have the charges against him thrown out of court. Chauvin, of course, was the former Minneapolis police officer who pressed his knee into George Floyd's neck, ultimately murdering him, according to prosecutors. They say Chauvin ignored training materials requiring suspects to be placed on their sides to recover after a so-called maximum restraint technique is used. That's a similar technique to what Chauvin was caught on video doing to Floyd, but not exactly the same. Training materials also required Chauvin to call medics after using a chokehold similar to what he actually did do to Floyd. Training materials further required Chauvin to directly render medical aid rather than merely wait for medics to arrive. Prosecutors wrote, the officers held Floyd for approximately 9 minutes, about 5 times longer than the national anthem and 4 times longer than President Lincoln's Gettysburg Address. During that time, Chauvin continued to kneel on Floyd's neck for about 4 minutes after Lane told the other officers that Floyd was passing out, and for 2.5 minutes after King said Floyd did not have a pulse. Indeed, he continued to press his knee into Floyd's neck for a full minute after emergency medical personnel arrived on the scene, and even while emergency personnel tried to check Floyd's pulse. So some interesting literary arguments there, Brian. Let's back up and look at the procedure here. Chauvin is saying the case should be dismissed because of a lack of probable cause. That basically means an ordinary person would have a, quote, honest and strong suspicion that a suspect is guilty of a crime. Is it easy or hard to get a case tossed at this point in the proceeding?
Well, as a defense attorney, it's remarkably hard. The standard is very, very difficult. Even before you get to that, Aaron, you have to realize that all the facts are in the light most favorable to that of the prosecution. So even then, if you're arguing between how a fact can be interpreted both ways, the prosecution wins on that one, so it's very difficult for the defense.
Prosecution gets the benefit of the doubt. So Terry, on the merits here, this looks like the state is turning this into a miniature trial about training. Is that a strong or a weak way to build this case, knowing what we know now?
Well, I'll give you a legal answer. It depends. You know, it could backfire on the prosecutors. They could demonstrate that the police department had sufficient policies and procedures and that the officers failed to follow those policies and procedures.
So yeah, certainly that's where they're going with things, Terry. And what I'm trying to figure out here is we've got all this literary flowering language about the Gettysburg Address, about the national anthem. It sounds good, but does it take the eye off the ball here? Because the bottom line is the state's trying to prove a degree of murder here, not whether or not he complied with a training standard.
Exactly. And that's where I think it could backfire on them. So if the jury thinks, well, the police did all that they could, they followed all of the policies and procedures, and there was nothing more that the officer himself could do, then I think that it could backfire on the prosecution, and showing these policies and procedures and focusing on that might really help the jury to come to a conclusion that the police did nothing wrong here.
I get very nervous when we focus on training because training procedures are not the actual law being applied in a case. And Brian, you're shaking your head.
I don't think.
Maybe.
You cross-examine a police officer, and this is what they want to do. They want to uphold their training manual and say, I do this. I'm such a great officer. I do this all the time. But if you can lock an officer into the fact that their training manual says one thing, and they did the opposite, their Bible, their testament, it is a strong way to dismantle that the officer knew it was wrong and did it anyways. I think it works pretty well.
Taking the prosecution side, Brian Buckmeyer. Well, when we return, the so-called doomsday cult mom makes a legal request for her upcoming trial that some defense attorneys find surprising. We'll unravel that mystery right after this. And now to a rather interesting decision by defendant Lori Vallow in her upcoming trial on charges related to the disappearance and deaths of her children. Vallow and her husband, Chad Daybell, are charged with conspiring to alter, conceal, or destroy evidence. The prosecutor wants to try both defendants at once, and Vallow's attorneys are saying in court papers that they are not opposed to that plan. Daybell, however, is adamant that the trials should remain separate in order to remain fair. That's the husband's argument. It's an odd departure for the wife, however, from what we might usually see in cases where two defendants are accused of committing the same crime at the same time. The cases are scheduled to go to trial next year. The state's key witness is a former friend of Lori and Chad Daybell, who created her own secret recording of the defendants. But at a pretrial hearing, Daybell's defense pointed out that she might have had the incentive to lie.
At some point, there was a question regarding the whereabouts of JJ, is that right?
Correct.
And at that point, you had advised him that you had JJ in your care, correct?
I told him that I had him and then I didn't have him.
Okay. So the initial time that you told him that you had JJ, that was not a truthful statement to Officer Pillar, was it?
Correct.
And when you tell a statement that's not accurate to a police officer, that's a lie, is it not?
Correct.
So you lied to a police officer, is that correct?
Correct.
And then at some point, how long between the time when you told that lie to the police officer regarding the whereabouts of J.J. Vallow did you correct your lie? How much time passed?
Till I spoke to him on December 6th, I believe. I could be off a day or two.
So approximately 10 to 12 days passed from the time you told your first lie to when you decided to come up with a different story for Officer Gilbert later on, correct?
Correct.
Okay, let's set the lie aside and talk about the tactics here. Terry, I'm used to prosecutors saying, yes, let's combine all the trials together. I'm not used to defense attorneys saying, oh yeah, let's go along with that plan. Is that a good idea?
No, that's not a good idea. I mean, what her attorney should be doing is defending the case for her instead of making sure that they look good in court. One of the motions they made was that she could wear street clothes. And then they agreed with the prosecution that the cases should be brought together. So that's not a good defense for Lori, but Chad is making good defenses. He is saying, let's keep the cases separate, and he doesn't want to be involved. And he's saying, or he could be saying, look, I had nothing to do with this. It just so happened these babies were buried in my backyard.
Okay, so Brian, I know you probably agree with the tactical decision to keep the trial separate, but can we look into this and say, is somebody getting ready to point the finger at the other one by having the other person present in court?
I mean, yes, but that's a very dangerous move to make. You've got to either be really confident in your defense and that of the other defendant sitting next to you, because they're going to point the fingers at each other. But when the jury sees red for one, they may see red for both, and that could definitely affect your client if you're the one trying to point the finger.
Very dangerous. Brian and Terry, great analysis here on Law and Crime Daily, and we will see you next time. Thanks for joining us for our discussions about justice in America.
I'm Dan Abrams, and this is the Law and Crime Network.
The only 24/7 network with expert legal analysis and gavel-to-gavel live trial coverage. Watch the Law and Crime Network today.